Okay. Your name, sir?
David Allen Sawalski, sir.
Okay. And there was supposed to be a written answer filed. How much is a non-payment of rent case? How much is you did file with that?
I wanted, sorry. I wanted a 1.5 month, $2,400 security deposit. And, now she owes $3,200 in, back rent because, I took over. What happened, sir, was I took over the property on September 26th. I bought it.
All right, guys. Today we're going to watch a case that starts calmly but immediately hints at trouble. The landlord opens confidently, explaining his claim, but within seconds the judge begins pressing on the basics. No written notice, no clear agreement, and vague numbers. This opening matters because it shows how fast confidence can crumble in court when facts are missing. The judge's early questions set the tone and quietly signal that this case is not going to unfold the way the landlord expects.
Okay, yes, I recall.
And so, for her to stay there, I would want $1,600 per month. But that started on September 26th.
What was it before?
That was between her and the previous landlord.
So at what point did you give her notice that was now her monthly rent?
Same date.
In writing?
No, sir. I knocked on the door and she answered it, and I told her that I want rent if she was willing to
On
pay.
what date did you do that?
September 26th.
And so then you were going to charge $1,600 for October?
Yes, sir. If she paid
then
it.
Let me just ask you this. Why do you think you would not have to give her 30 days notice at minimum before you change any condition of her rental circumstance?
I'm not sure about that, sir.
Yeah, I can tell.
Yeah.
So
we had no agreement.
Your Honor, he came to my door and my daughter was there. Both of my daughters were there when he offered me the agreement and said he liked my dog. He said that he did not want to bother me for a down payment and that he would honor the $1,200 a month.
did you tell her that?
24
No,
hours
sir.
to think about it, and I called him back and said, I agree.
Hold on a minute. Okay, but
No, sir.
so what are you claiming she owes?
Well, I for her to stay there, I wanted.
No.
Okay.
You filed this as a non-payment of rent case, saying
Yes.
that she hasn't paid rent.
Yes, sir.
And in that complaint,
Yep.
you basically indicated that, first of all, your complaint doesn't say anything about how much she owes at all. That's blank. Then you're saying that the rental rate is $1,600 per month. What I'm hearing is that is not true.
Buckle up, guys, because this is where the story cracks wide open. The tenant finally speaks, and her version directly contradicts what was just claimed. The judge stops letting things slide and points out that the complaint itself is incomplete and unclear. You can feel the shift as the courtroom energy changes. What looked like a routine non-payment case suddenly turns into a credibility problem, and the landlord is no longer controlling the narrative.
And
I originally offered her, sir, $1,200 if she paid me that same day.
okay. Your complaint indicates there's nothing about a $1,200 offer. I don't know what this whole offer thing was, and I'm not necessarily, at least at this point, going to get into it. But there was no agreement between the parties, and assuming she's, say, a tenant at will, or that you would change a condition of her tenancy, that you gave her properly 30 days notice to up her rent, yet you filed a complaint that says that the rental rate is $1,600. Frankly, sir, that's false.
Okay.
Then you don't say, you say no rent is due, right?
Which item is that, sir?
Pardon?
Which item would that be on the complaint?
Look on your complaint, paragraph 5, C and D.
Yeah,
There's nothing.
yes, sir, I overlooked that. I'm sorry.
Then, so if, as you're indicating, you purchased the premises, if she were a tenant there, what happened to her previous security deposit?
I don't know that she, I have no idea. I have no idea if she paid one.
I did pay one, that's why I feel,
Well, hold on. Just hold on, ma'am. Just take a breath, please. All right. How much did you pay as a security deposit?
it was $2,400.
Thank you. So,
All right, guys, this moment is critical because the judge stops dancing around the issue and calls it out directly. The complaint does not line up with the law, the rent increase was not properly done, and the paperwork simply does not support the claim. This section shows how procedure matters as much as facts. Once the judge labels parts of the complaint as false, the case begins sliding downhill fast.
if you purchased the premises, you would have had, she was still in the unit. That means you purchased it subject to, I'll put it in legal terms, her leasehold estate. You then become her landlord, which means that then you are the one that is responsible for the holding of her security deposit. So where's her security deposit?
Well, I have no idea. The previous landlord told me she hadn't paid for 13 months.
That was a,
I'm
sorry.
And he told me he had no
I don't
deposit.
I don't care what the previous landlord said.
Yeah.
But if you took subject to a leasehold estate, you would be required to figure out, I've got a tenant in there, have they paid a security deposit? Because then you're the one that would retain it, or he's got to return it to her. But I don't know how you ask her for another security deposit, because here's what would end up happening. Presumably you've taken that $2,400 security deposit. That security deposit that is she previously paid, and any security deposit the tenant paid, is never the landlord's money. It belongs to the tenant. Which means that if, as you want in this complaint, for her to pay another $2,400, that means she would have theoretically a $4,800 security deposit. Even if I were to permit you to have the $1,600 rental rate, which I don't think can be imposed, you would only be able, 16 plus 8 is what, 24? The maximum amount of her security deposit could be 24, which means that you would be charging her twice the amount of a security deposit that legally you could require that she pay, which is going to subject you to damages.
Okay.
So that's where we are. To be honest with you, I think you bought this property without fully thinking through what you needed to do. You can't force this woman to do certain things and just automatically like appear at her door and claim that your rent has gone up by a third.
Yes, sir.
On my say so.
Yes, sir.
Where in the heck does the $4,000 come from that you're saying that she owed? Oh, that's the $1,600 that you're claiming, which is the improper rent plus the improper security deposit.
Yes, sir.
That's where they comes up in the notice to quit?
Yes, sir. I wanted the 1.5 month security deposit plus the $1,600
You
a
need to
month.
go to the previous owner and find out where her money is. Because you're supposed to be the one now that's taking over a leasehold estate. You're the one that's supposed to retain it. And you're supposed to give her a notice of where you're retaining it.
Is she required, sir, to provide proof that she gave a security deposit to the previous landlord?
Yeah, I have my
Hold on.
Buckle up, guys, because this is the heart of the case. The discussion about the security deposit completely flips the situation. The judge carefully explains that the deposit belongs to the tenant, not the landlord, and that buying a property means inheriting those responsibilities. The math makes it worse, showing how the landlord could be demanding an illegal amount. This is where legal exposure becomes very real.
You are requiring her to do some things and shifting the burden to her. I will call upon her to provide proof when it's necessary to provide proof, but I don't see anything in the beginning of this that you did that's right. At all. Have you asked the previous landlord if he has her security deposit?
I did not, sir.
See? And so now what you want me to do is ask her whether or not she paid it. Quite frankly, I'm going to say this to you. I'm not sure what she wants to do. But what's going to end up happening is both you and the previous landlord are going to end up getting sued. So my question becomes, what do you want to do with this case?
Well, indeed, if she paid a security deposit to the previous landlord, and it looks like the security deposit I asked for is no good.
Well, but where is her money? The security deposit, did you hear what I said?
Yes, sir.
The security deposit belongs to the tenant and is to be held by the landlord, but it's her money.
Yeah.
So somebody needs to find it.
Okay. So I would need to contact the previous owner and see what...
I don't know what you would need to do. All I'm telling you is somebody needs to find out where her money is.
Okay. I'll contact...
Moreover, the complaint, while you certainly could amend the complaint, the one thing you cannot amend is the notice that you sent to her. That notice has numbers in it that make no sense based upon what I've just told you. However, you did file a notice that on its face looks valid, so I can't necessarily dismiss this case on subject matter jurisdiction. However, if you wish to proceed with this, you need to understand that at the very end of the complaint, and pursuant to the court rules, that you're signing that complaint under penalty of perjury. That information has to be true. I don't think that any of this is true.
Okay.
So you can make your decision as to whether or not you want to proceed with this case or not.
Well, I think it might be better to dismiss it and pursue possession.
Well, because she asserted her rights?
Well, because if she put
Sir, get what you did.
Yeah.
You went to this woman, told her, based upon some representation that somebody else made about whether she's paid rent, not knowing the circumstances. Not sure that was any of your business, but that okay. You took the place, didn't get her security deposit, asked her for another security deposit, and then try to increase her rent by a third. So here's what I'm going to do. Okay? I'm going to adjourn this out 1 week. You think about it. You try to figure out. I'd suggest you go get an attorney. Because if she turns around and files a claim, you're going to have a heck of a time. I'm just going to be honest with you. But that's going to be your call. I am not, because it's not in her interest. She's unrepresented by counsel. I'm not going to, and she's appeared. While you're moving to dismiss, I'm not granting your motion to dismiss at this time so that she can also pursue whatever remedies she may have if she chooses to do so. So I'm going to adjourn this out to November 7th, 2025 at 1 p.m. That will also be an in-person hearing. And I am not precluding the two of you having a conversation, provided you want to approach her as your equal. Thank you.
Thank you, sir.
Have a good day, ma'am.
1 p.m., November 7th.
1 p.m., November 7th.
All right, guys, this is the fallout. The judge openly criticizes how the property was purchased and managed, warns about possible lawsuits, and explains the risks of signing a complaint under penalty of perjury. Instead of dismissing the case, the judge protects the tenant and adjourns the matter, urging the landlord to get legal help. This ending makes one thing clear: rushing into court unprepared can backfire badly. If you found this breakdown helpful, make sure to like the video, subscribe to the channel, and we'll see you in the next video.